I want to talk about everyday type of stuff, and this is where this little law becomes extremely dangerous. Actually, appealed the case all the way to the Texas Court of Criminal Appeals, the Supreme Court, basically over criminal cases for Texas, and about child pornography and tampering with evidence. You say, well, why are you defending somebody in a child pornography case? Well, everything is not so clear as what the media puts it and just what the words that go to describe a case. There's facts in a case that make it different and not the same as any other, okay, and not the same as the typical case that maybe you think. And so here's some of the problems with this rule. It talks about a person commits an offense and we have two I would say pillars, right? You have one when there's an investigation, and you have one when there's no investigation. Okay, and so one we're looking at is an official proceeding, okay, or investigation pending or in progress. Okay, now Matt, let me ask you this.
Yes,
when I say pending investigation, what is that?
It's pending. It's in the process. It's there. You're waiting for its results.
Oh yeah. So then what's in progress?
Pending is it's going to happen.
Good, right? About to happen, right? I wouldn't have thought of that. I wouldn't have thought.
No. What if you had the case and it was done and you're pending its outcome?
That's
what I'm getting at.
In progress.
Okay, we're getting technical.
Hey,
see this?
Matt,
I'm splitting our hair.
Words mean things.
Man, I got asked this question right when I was at the beginning. First month lawyer. The lawyer asked me, what's the difference in pending and in progress? I couldn't answer. Right? It's a hard thing to answer. I mean, that's the dictionary definition of pending, about to happen. But when we say a pending investigation, we feel like it's going, or it's about to have a result. That's what I would have said. The same thing you did. Okay, and so when I just talked about there's two pillars to the statute, right? There's the subsection A and there's the subsection D. Okay, A talks about pending investigation or in progress. Well, pending, about to happen, means it's not happening. So what's the difference really in A and D?
You just spun me around the block here.
D talks about no investigation. It could be used later in an investigation. Well, is we talking about there's no investigation even pending, or any time at any point in time in 20 years from now? That's tenuous. I mean, it's so remote from what would be going on in your mind at the moment. Okay, there's got to be some awareness to the criminal law, and so how are you to know if an object could be used as evidence in a pending investigation or even an investigation at any time? Okay, yeah, sometimes obviously we know. Okay, but there are some things. How do you know what's going to be evidence and not evidence?
I don't know. No,
this thing is so wild. You say, well, they wouldn't prosecute
you can't
anybody.
see this on the radio, but I'm giving him a very stupid look due to ignorance. I'm like, okay, keep going. I want to figure this out as you keep going on.
People are prosecuted for these crimes. Oh, and by the way, if you think that police officers, I have in jury trials all the time, we ask a question. On a scale from 1 to 10, who thinks that police officers break the law? And we mean break the law in the course of their duties. Okay, we get, and normally the people are like sometimes, seldom, but they do it, and some people go all the time. Okay, right? Then you got people, and those are unreasonable people too. I don't think they all the time break the law, right? And then you have people who say never. Well, for those of you who raise your hand in these jury trials, and we ask you serious questions, and you say never, right? Come to my office, and I'll show you the number of times that cases have been appealed because police officers have tampered with evidence.
Is there a separation between tampering because they did it on purpose or they did it accidentally? Can you break that question down that way?
Oh yeah, you're gonna have specific intent to this thing, or at least some specific knowledge. You got to
make a big difference on the answer.
Right. If knowing that an investigation or official proceeding is pending or in progress alters, destroys, or conceals any record, document, or thing, and so I like to just say anything. Let's just, because that's what it says. It says anything. So alters, destroys, or conceals anything with the intent to impair its verity, legibility, availability as evidence in that investigation or proceeding. Okay, you see how broad? So you are going to have this intent factor. You're going to have this specific intent, right, to destroy it, alter it, or conceal it, right, with the intent, right, that it affect this particular thing. Okay, you're also going or makes, presents, or uses anything. Okay, and it says document, record, blah blah blah, but it says thing. So anything, right, with knowledge of its falsity and with intent to affect the course or outcome of that investigation proceeding. Okay. That's a lot of words there, but what I want to get to is, yes, there's a specific intent. You have to have the intent to do the thing. Mm-hmm. What does destroy mean?
To eliminate from the possibility of being used.
I would say that's probably the best, just off the cuff definition I've ever had anybody tell me.
Thank you very much.
Right, but so when we look at these words, every one of them is ambiguous, and the courts have struggled with destroy over and over and over again. And so they talked about, they said, destroy means it's got to be absolutely destroyed, right? Well, then that would mean if the state entered evidence of the thing, that means it had not been destroyed, so then the state has no case, right? But then the state would argue, no, if it eliminates any of the evidentiary value, any of it at all, right, then it's destroyed. Well, that's too broad, right? Any value, if in other words, like if my guy has a marijuana cigarette, okay, and the police come to stop him, and he rips his marijuana cigarette in half and throws it in the ditch, okay, but the police go and find both halves of the, is that really destroyed? Because there's two pieces now.
Or it'd be the same thing as he got one and he smoked half of it. Does that mean it's still not? It's not
yeah, exactly. So and you've had these cases come up where kids are getting stopped and they'll just eat the eat the 8-ball or eat the marijuana cigarette or just trash the cigarillo, whatever they're trying to do. These cases have it all the time. I'm telling you. And I've had cases where the guy has the crack pipe, okay, and drops it when they're grabbing him, right? They're grabbing him to put him in handcuffs, and the crack pipe comes out of his pocket, falls on the ground, and cracks, breaks, and he gets charged with tampering. And I'm like, man, dude,
that's the true meaning of the word.
I mean, it's not destroyed, it's not concealed, it's not altered, or is it altered? Is it altered? And so you get into these cases and you're just this statute is very frustrating. I think it's overly broad. It lets the state get some good leverage in some cases when they need leverage, okay, but in other times it's very dangerous, okay. And so I want to go back to the child pornography, electronic sexual visual material depicting a minor, okay. And so those are two different laws, and one of them talks about obviously the child pornography, right? And you can't have any kind of material that depicts the areola or some other kind of private part of a child, and child means younger than 18 years of age, 17 years of age in child pornography statute, okay? And so the visual material is going to be the same kind of issue, right? But it's something that will be transmitted between minors. Okay, or something that was sent from a minor to another adult individual. Regardless, both of these things make it illegal to possess some kind of sexual, right, depiction, okay, of a minor, which is going to be under the age of 17 years of age. Okay, 17 years old. You say that's good, that's real good. I'm glad we have this law. Well, you can actually have sex with, right, someone who is going to be, I think I got this backwards. We're talking about, so a child's going to be younger than 17 years of age. Mm-hmm. Okay, so a minor's going to be anybody that's younger than 18 years of age. So you could actually have sex with a 17-year-old, okay, but if you take pictures of it, you're in possession of child pornography. Okay, I said this backwards. I didn't mean to mess up, okay? But it's going to be, so a child's going to be younger than 18 years of age. Does that make sense?
Yes.
Okay, and a minor's going to be younger than 17.
17 or younger, yeah.
Okay, so you could have sex with, right, the 17-year-old, but you couldn't take pictures of the 17-year-old. And you say, well, why should you be taking pictures anyway? What if you're 21 years old, going out with a 17-year-old who's a senior, right, in high school, okay? And she sends you a picture, right, of herself. You guys have been sexually active for years, okay? All right, and she sends you this pic. Maybe not years because that would be illegal, right? But hey, let's say you've been sexually active. I meant months.
Yeah,
all right,
I know what you mean.
I got tongue tied earlier, so then I just keep snowballing. Okay, you've been sexually active for months, right? At this age, she sends you a picture. You didn't ask for it. What do?
Delete.
Now you've tampered with evidence.
Oh. Oh no!
You can't possess
So
it.
it's a double-edged sword.
Okay, I know I
sword.
stuttered, but I want you guys to see the
If
importance.
I
of
get
this.
it, if I get it, I'm quote unquote screwed. If I delete it, I'm screwed.
I'm the 21-year-old. I can absolutely have sex with her. She's over 17 years of age.
Understood, but it's the pictures that you can't have.
But I cannot have the pictures. I didn't ask for them. She sent them to me.
But you're still in possession of them. There we go
And
back.
so I'm in possession of child pornography.
Based on what you say, yes.
That's true. That's absolutely true. I'm not what I want to say. That's true. I promise you. Right? I appealed on this ground.
Okay.
And they haven't changed the law since.
I'm saying this is what you're saying, so I'm saying that's what you're saying. Okay, based on the law, that's illegal to have.
That's wrong. There's nothing I can do. There's nothing I can do. Okay? And you can go read some of the record in the appeal, right? What if I'm not going to say any particular facts of the case. I don't want to.
Well, wait,
But what if you go to the parents? You're stupid because they're going to call the police. They're going to call the police. They're going to call the police and say, "Why are you taking pictures?" Blah 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 blah. Unless you're in a good relationship with them, right? That's not weird. A good. That's weird, right? Who's going to do that?
Okay, now just roll it back and explain how this is tampering with evidence. Okay, so here you got this picture sent to you by the.
If you delete that item, right, you have effectively destroyed.
But if you don't delete it,
you're in possession of child pornography.
So what do? Throw the phone out?
This is a great issue. I mean, it's not a great issue for you, right? If you're the 21-year-old, okay.
17-year-old sitting back laughing.
But it's a great issue for me because I'm gonna charge you $10,000 to try to fight this case.
So how do you win it? It's like a two-edged sword. You can't win it.
It's hard. And it's stupid. This is a dumb idea. But this happens. This could be the case with anything.
But you're.
Let's say somebody sends you a picture of the murder weapon.
Let's do that because with this other one, there's no way to go. I want to get people to understand why. When you talked about the picture being sent by the 17-year-old, and you delete it, you tampered with it, but you're screwed on the other sense. Let's talk about the picture of the gun here. Has nothing to do with age. It's just an actual item for a crime, and you delete the picture. Now let's talk about tampering with the evidence.
Yeah. So then, what is conceal?
To hide from plain view, reasonable person.
Is it, or is it a failure to disclose?
I guess it all depends on the discussion you're having.
Exactly. It
How much
depends
is
on
in
whatever
two?
the judges say they want the result to be.
Pause. Awkward pause.
That's what's true. I'm telling you. Look, they conceal. No judge would tell you that a failure to disclose would be conceal, right? But I'm telling you that these definitions are so problematic, and these words in this thing are so problematic that they're not being given their reasonable application. And so you have cases where people have just failed to disclose things, okay, without ever being asked to disclose it. Okay, and have gotten in trouble under these kinds of laws.
So what is the advice to people who come under these certain...
My advice is that this kind of law right here is extremely dangerous.
So how can one protect themselves against getting...
And sometimes there's no good answer. There's no good answer.
Can you give a few relative ideas or examples of how that could pertain to maybe
I think if you've got a good answer, I mean a good history, a good record, right, and you've got some kind of rapport with local officials, I would say that if somebody sent something to you and you really have done nothing wrong, right, and you feel comfortable, go ahead and go to the police station and say, look, especially like something on your phone, like, look, this was sent to me. I don't want nothing to do with this. Like, think about it, man. What if your buddy sends you some picture of some girl he thinks is hot, right, and you looking at it and you think, holy crap, I think she's too young. You think that doesn't happen? What if this happened? This is a real case. right? What if I keep going back to this dude? I can't get over it. It's one that just irked me, and it's irked me since my appeal. I mean, I lost that appeal obviously, but there were some other facts that the court, I think, just didn't want to hear right then. And we ended up getting that one dismissed, and some other things happened. So, but my point is this: what if you have a right to be able to avert your eyes from any speech that you don't agree with? You don't agree with that?
Say it again.
I've got a right not to look at or listen to speech that I disagree with.
That's correct. Yes.
Okay. So in other words, this was said by the Supreme Court, right? In the
Change
case,
the dial. You don't like the show? Change the dial.
right? Exactly. Okay. And so, if this is true, why do I not have a right to dispossess myself of communication that I don't agree with?
That's a perfect example for Alex Jones and Infowars. I'm not going to get into that. I'm strictly stating him getting cut off. If you don't know who that is, look it up. But him getting cut off because they don't like him is a major freaking no-no. If the guy was doing something wrong, it's different. But to take somebody's speech away because you just don't like what he's saying, change the freaking channel. I have paused. Go back.
I'm talking about government, right? Control over one's First Amendment rights.
I know,
to
I know,
speech.
but the government's supposed to protect your freedom of speech. And that particular individual's freedom of speech was being cut off because he did nothing wrong other than speak his mind. But I'm sidebarring here. Go back.
So in this situation, right, does the government have a right to tell me I cannot dispossess myself of communication I disagree with when I've got the absolute First Amendment right to do so?
Yeah, that's right.
Okay, but saying that I can't, right, under the tampering with evidence statute, right, now causes me to have criminal liability. And if I've got to go and turn over this communication, then I'm also effectively, right, incriminating myself.
Okay.
When I also have a Fifth Amendment right, not to incriminate myself.
Ladies and gentlemen, I want to make something clear here. I'm 55 years old, and I'm one of the most average Joes around. My brain capacity is average. Everything about me is average, okay? Ross, you're talking some great stuff here, but because I'm average, I'm listening to you. I don't know what to do right now. Tell me.
There are two things.
Wrap it up here. We got time. We got plenty of time. But swing us back around as to how somebody with all this information that you're putting out can do something.
You just
to
don't
protect
understand. I don't think you see what I'm saying.
I
I'm
just
telling
said-
you
I just said
how
it.
many rights this violates, right? Because there is no good answer.
Okay, so what does
And
somebody do?
some
when
of this,
there's
you're
no
asking
good
me what
answer?
to do, and I'm telling you that under this law, many times there is no good answer. The prosecutor would say, "Well, come to the police station. Come to the police station. Turn over. You won't have a problem." Yes, you will. And if you do that and you've got a criminal record, you're going to jail. I'm telling you from the defense side. So you want to hear it from a public official standpoint, we're not going to take you to jail. The best thing for you to do is come to the police station and turn that over as for use of evidence in the thing. Now, I'm telling you that doing that, right, is not always going to be the best course of action because you're going to get yourself in trouble. And I can tell you that from my own experience. I've seen it. Somebody tried to go to the police, turn it over, and they end up going to jail. And they end up getting accused for it.
So instead of calling up the local police chief, they should be calling up their local Rick Dodd or Benton Ross Watson.
I would say maybe you can contact an attorney and, try to have the attorney turn it over to the police and be anonymous about who the giver was, but then you're putting me into a situation of concealing evidence because they're going to want to know who turned it over to me. And I don't know that it's arguable whether the identity, right, is necessarily privileged, but,
So then the answer is get rid of it and pray for the best. Okay, that's with digital evidence you're saying.
You see, I really didn't give you an answer that was verbal. But I guess you guys can go watch YouTube after this is over. Okay? I mean, I don't think that's, I'll say this, I don't think that's always the bad answer. I think that is sometimes probably the answer. But for me to say that is me advocating for you to tamper with evidence.
Okay.
And then so the government gets in these situations too where they want you to like voluntarily disclose information. And I'm thinking and the statute itself has a provision there that talks about information that's privileged or information that's work product, okay, does not apply to this thing. But I want to show you this other defense that says it is a defense to prosecution that the record, document, or thing was visual material prohibited under the visual material depicting a minor statute and was destroyed under F3B. F3B applies to another minor. So if another minor destroys it, they allow that minor to destroy it. They don't give adults any defense.
Okay.
And so my point is, the legislature, and you can go read the legislative history, the legislature is aware of the great threat, right, that people are in danger of coming under, right, with digital criminal material. And they know this. And they talked about, well, they don't want kids to be in trouble who just receive information that they didn't ask for.
What?
And so they give them a defense to destroy that information. The same applies to adults. And I feel like the legislature should have given an adults a defense to destroy information that they didn't want either. And in my opinion, this is a violation of equal protection.
Have you done that in court?
Yes, I've litigated this hardcore.
And how does it go for you when you do that?
I get mixed emotions, and judges probably like you. I don't understand. Judge, if I sent you a naked picture, right, of a child on your phone, Judge, what would you do?
Delete it.
You've just committed a third-degree felony, Your Honor. That's been my best tactic.
And so the judge will go, you got me on that one.
Yeah, and then they look at the state and go, what are they supposed to do? And the state, well, we just want you to uphold it, Judge, because there's no other law that says this, and this is what we want you to do. Okay, that's what I'm going to do, right? And then I appeal it. Sometimes judges agree, sometimes they don't.
Wow. When you made it in that example, it just all brought it to light. It was clear. It was a lot of stuff there. I was trying to follow you and looking, and I'm scatterbrained today, so I didn't get it. But when you did that, I get your point. It's like, hey man, you're damned if you do, you're damned if you don't. We got to fix this problem.
And this is what I'm saying. You want me to give you an answer about what to do? There is no good answer in this situation, and it's a great threat. It's a realistic threat. It's something that happens, right, probably somewhere in this country every day, at least once, right? If not several, thousands. Okay. But it's something that really needs to be changed. Okay, and there needs to be a push from the public to your officials about this kind of thing. Okay, because it's not fair. And I've talked to judges that I haven't had the case with and told them about it. They say, wow, man, that is crazy. And I said, what if I want to sabotage your campaign? All I got to do is, what if you're a stepdad or a preacher that the kids don't like?
Wow, you just planted a million seeds out there, man.
Hey, I'm just saying, this has already happened. I'm not planting seeds. This has already happened. People have already gotten set up like this.
Without mentioning names, you talk to people in these positions who can make a decision call, judges and so on and so forth, before they've had a case like this. Do they, or if they haven't had a case like this, do they uphold it out of fear of repercussions because they didn't uphold the law, or can they go off of that and say, I'm going to call this the way it is?
Hey, I'm not mad at anybody on any of these cases. It's the legislature's fault, right? It's the legislature's fault. They don't give us a defense here. Okay, the judges are just trying to do the best they can under what the law has stated. It's not their fault either.
But can the judge say, screw the law, I want to judge this way?
There could be some rights for them to say that, right? But they're going out on a limb saying that, and then they're going to have the DA's office hit them politically, like he just let a person with possession of child pornography off. What are we doing? And it's not really that kind of case, you know. It's not there. And then, you know, some judges will be like, look, I'm not going to dismiss the case, but I'll let you argue that to the jury. Well, Judge, you're putting my client at an extreme risk, right, for no reason when it's not when there's no dispute about how he got this thing. Okay, and then sometimes the DAs say, look, they just want to be right, and then after I'm right, they go, look, we don't want to try this case. Let's do what we can to make it go away. Okay, and so, I mean, it's just a realistic thing. I'm just telling people to be careful, right? Especially about who they give their phone number to now, too. Because if somebody's got it...
Ross, what you do is kind of what I do in what I do in my classes. And that is, I take the laws and I look at them word for word. I ask questions and talk to you about it and all this kind of stuff to get clarity on what the law says. And people say it doesn't really mean that, or this isn't going to happen. But I'm the one who looks not 3 steps down the road, but 5 steps down the road. And it's at step 5 is where I see the problem where that law comes into play. And what you're doing here is clarifying and opening up people's minds, and it goes down 5, 7, 8, 9, 10 steps down the road to see where the house of cards are going to fall down on you. So I think that's really good. Knowing and understanding the laws and what they mean and the double jeopardies in them and the parts that can get you when you thought you're doing right, it's just good to know. So that's why these segments are very good. Ross and Rick, they're excellent what they do. We got the YouTubes that are up. You need to go check them out on all these different.
I mean, watch too. Like people, you know how people vomit at the mouth on their Facebook messages, right, or in text messages when they're mad at you. I haven't had any love life in a while. So, but you know, when you go and you're in, I didn't have a cell phone in high school, but maybe in college, you know, the other paramour is mad at you and they just go off in a text message, and it's like it's like reading a book, and they're just like going off on you. If that's evidence, if it's ever evidence of anything, right? We talked about the no investigation, right? It doesn't have to be an investigation, but it could be evidence later, right? And so it doesn't just apply to these pictures of child pornography. You could have a confession or something, right, within, right, a text message that you don't really know what to do with. Do you have a right to delete it? And my argument is absolutely you have a First Amendment right to dispossess yourself of communication that you don't agree with, that you don't want, right? Where the state's argument is going to be, you have a duty to turn that over. You have a duty to turn that over to a law enforcement authority. And these technology and law is going to come. They're already coming to an extreme clash, right? And they're going to continue to butt heads for a long time until we figure some of this out. And so that's why we do this show, to try to help people and to try to encourage people to reach out to their government officials, reach out to their politicians, local people that have some control, and to make good decisions in these elections so that we're getting reasonable people in office that can make reasonable decisions that we're not scared of.
Okay, I want to just wrap it up by saying one thing. Tell me if I'm right or wrong. You're a concealed carry holder. You're being confronted by somebody, and you do reckless injury, potential recklessness, not injury, but recklessness, because you took out your semi-automatic pistol that carries, let's say, 15 rounds, and you shot 15 times but only hit the person once, and you pick up 14 shell cases, put them in your pocket, and they think you only shot once. Is that tampering with evidence?
Absolutely.
Okay, and that's what you don't want to do. It's a physical example. So if you're there and you don't know how to shoot,
when you picked them up and put them in your pocket, did you go throw them in the trash?
You did not want to show that you shot so many times.
Yeah.
Okay, that was just a quick example for somebody simple like me to understand the concept of tampering with evidence. Okay, Ross, tell everybody how they can get a hold of you, and go ahead.
My name is Benton Ross Watson. You can contact me at 105 East Main Street here in Cameron. Got the big milk cow on the side. You can email me. Hey, we love emails and questions like that. If you do email me at Benton@Watson.legal, Benton@Watson.legal, make sure when you email you leave a phone number, because I can't always email you back, but I will call you back if you leave a phone number. You can also call me to schedule an appointment here in Cameron or in College Station or Houston at 254-605-4140. That's 254-605-4140. Again, Rick Dodd, appreciate you sponsoring the show. Thanks for calling me on and always being there, man. I appreciate it.
It's always a great time with you guys. Thanks a lot. Ladies and gentlemen, we're going to take a break. Trey, let's take a break.